For the past 40 years, reproductive rights have been a major topic of discussion amongst American citizens in the United States, and the U.S. Supreme Court has actually remained relatively moot on um, any cases involving reproductive rights or abortion cases simply because of the precedent established by Roe v. Wade in 1973. I examined a New York Times editorial in which the author makes a claim that the Supreme Court made a good decision in not reviewing the appellate court's decision on an Arizona law deeming it unconstitutional that would ban abortions at 20 weeks. So, in this editorial, the author utilizes two main points to really argue their case. The first is that the law was unconstitutional, as well as that the law was consistent with 40 years, or the ruling was consistent with 40 years of legal precedent. I completely support these two claims. They provide some reason as to why the Supreme Court made a good decision in not reviewing the appellate court's unconstitutional ruling. However, the author does not go far enough into explaining why the decision was actually a good decision. I will discuss further reasons as to why I believe that the decision is actually a good reason, a good decision. So the main claim in this editorial, as mentioned above or before, is that the Supreme Court made a good decision in not reviewing the appellate court's unconstitutional ruling on the 20-week abortion ban law in Arizona. And I agree with this claim of value. Like I said, I understand the point. It really helps argue the case. The law was unconstitutional because of the precedents established in Roe v. Wade, where they used 24 weeks as the cutoff before abortions could be banned, and this law cuts it off at 20 weeks. And the reason why 24 weeks was utilized was that it was the normal fertilization period for women. So, with that said, the author does not go far enough into explaining why the main claim is actually true. So, according to a New York Times article, the Arizona governor, Jan Brewer, actually championed to make Arizona one of the most pro-life states in the United States, as well as the law that she signed completely fit into her track as one of the most pro-life governors that Arizona has ever seen. So this in itself explains why the rule or the law was passed in the first place. It just fits perfectly, aligns perfectly with her ruling, her beliefs. Although she has these beliefs, though, it's important to note that the federal law, federal rule, federal whatever, always trumps state rule, state law. So as we've seen with the outcome of the case, the federal precedent overtook her beliefs. So, and the Supreme Court's inaction on this further explains the previous point that I just mentioned. This would be considered inductive reasoning due to the correlation that I'm making between the governor's beliefs leading to the law being signed and implemented, as well as the law eventually being deemed unconstitutional, thus leading to the good decision of the Supreme Court not to review the appellate court's decision. And the author failed to mention that this was actually the third time during the term that the Supreme Court decided not to review a lower court's decision that struck down a restrictive state abortion law. As mentioned before, the Supreme Court typically doesn't really review cases like this simply because of the precedents established by Roe v. Wade in 1973. But this example from the Washington Post would be an example of inductive reasoning because it strengthens the main claim through showing a correlation between this being the third time during that term that the Supreme Court did not review restrictive abortion state law, and the Supreme Court making this good decision to not review the Arizona law. Last point is that the state abortion laws, some state abortion laws have already been blocked at this point. So both Georgia and Idaho had already had their laws blocked up to this point, and this point should have been included into the editorial to kind of strengthen the whole overall aspect of the main point. This would be inductive because we use examples of other states having banned pro-life laws to show why the Supreme Court made this good decision. In conclusion, the author makes a lot of good points as to why the Supreme Court made a good decision, But again, I feel like they didn't go far enough into it. So with the inclusion of Jan Brewer's beliefs, this being the third time that Supreme Court has done something like this that term, as well as both Georgia and Idaho having their laws blocked, um, the author could have had more of a rounder, structured, stronger argument with evidence, strong evidence to support the main claim of it as well.